So we don't have stand your ground in Connecticut. Let's be pretty clear on that from the get-go here.
Oh, it says it straight out.
So stand your ground does not exist in Connecticut. Castle doctrine, for layman's terms, is stand your ground in your home and only in your home. Welcome to Lock and Load Podcast. My name is Josh.
And I'm Michelle.
And we talk to you about Connecticut 2A issues. So today we are talking about the highly requested Castle Doctrine. You guys have kept asking us for that, and here we are. We are going to preference this entire podcast episode by saying we are not giving you legal advice. We are not attorneys. I am a USCCA instructor. I will be reading from USCCA certified curriculum. And we will be reading from the state of Connecticut OLR research report.
Now, the OLR report is dated from April of 12, but nothing's changed since.
Correct, yes.
So just so people know.
So we're going to go through some slides I printed off from USCCA curriculum. We're going to go through the OLR report. We're going to talk about Castle Doctrine. We'll talk about stand your ground, what that all means in Connecticut. We'll talk about what deadly force is. We'll talk about what reasonable force is. We'll go through what can happen when you don't do that as well. So if you've never taken a USCCA mini class, this would fall under like should I shoot or legal use of force, that curriculum. We offer those classes here sometimes for free through the USCCA. So like social media, if you're a USCCA member, you'll get email blasts about that stuff too.
Great.
They're great and free classes. So yeah, they're out there.
Information's always good.
So let's start off with what Connecticut defines as a Castle Doctrine, and then let's break it down more. So I guess start off with that OLR research. So that's yours. So that's yeah.
Okay. So I'm going to read through this. So, just bear with me. But the definition of Castle Doctrine. The Castle Doctrine is a common law doctrine that designates a person's abode, or in some states, any place legally occupied, such as a car or a place of work, as a place in which the person has certain protections and immunities and allows such person in certain circumstances to attack an intruder instead of retreating. Typically, deadly force is considered justified homicide only in cases when the actor reasonably feared imminent peril of death or serious bodily harm to oneself or another. The doctrine is not a defined law that can invoke, but is set to principles which is incorporated in some form of the law in most states. 46 states, including Connecticut, have incorporated the Castle Doctrine into law. Now, in Connecticut, I'm going to go over briefly. It says, this state states that a person who possesses or controls a premises is licensed or privileged to be on such premises, is justified in using reasonable physical force upon another person where he or she reasonably believes it is necessary to prevent or stop someone from criminally trespassing. Deadly force is reasonable only, 1, to defend oneself or another, 2, when one reasonably believes deadly force is necessary to prevent an attempt by the trespasser to commit arson or any violent crime, or 3, to the extent that the person reasonably believes it is necessary and only to prevent or terminate an unlawful entry by force into his or her dwelling or place of work.
So I'm going to interject and let's define what reasonable force means in most states. So this is very generic curriculum that covers Connecticut. This isn't Connecticut specific, but it also is at the same time. Most states will define reasonable force as the minimum level of force required to end the threat without going beyond that level. It can be thought as a level of force that does not exceed that threat. We'll give you an example. If a threat to you included the possibility that you'd be bruised or received a bloody nose, it wouldn't be considered reasonable for you to respond with a level of force that could break bones or permanently disfigure your attacker. So that would be reasonable force. Deadly force.
So if you pinch me,
you can't punch me in the face.
I can't break things?
No.
I just go, ow.
I guess you could pinch me back.
Okay, gotcha.
I think that would be reasonable. Now, deadly force. And I asked this question a lot during class because I like to see different answers. And Michelle and I pre-podcast were talking about this, and I was like, hold on, let's just ask this on the podcast. So, Michelle, what do you think deadly force is?
Deadly force to me is deadly. It means you've ended the attack or the intrusion by killing somebody.
Okay, so a gun,
a bat, a fire poker to the head, whatever the case.
Fire poker to the head. That was very specific.
Well, things happen. It's
okay.
A pipe, whatever the case may be, but doing something which would cause deadly harm means they die. That's what I would think.
You're on the track. That last part was
they don't have to die.
They don't have to die. So deadly force is any force that can result in the death of somebody. They don't necessarily have to die. So if I take a metal baseball bat and hit you in the head with it and you don't die, it's still deadly force.
Really?
Correct. So,
okay.
Deadly force, going from the curriculum here, I like to give the proper words. Deadly force may only be used when there's imminent danger of immediate and unavoidable danger of death or grave/great bodily harm to an innocent person when no other option exists other than to use deadly force.
Wait a minute. I have to interject. They said to innocent person.
Correct. So each state defines what innocent means, imminent, and grave or great bodily harm means. After any use of deadly force, the prosecutor or jury is going to determine whether they agree with your interpretations of those definitions. They will have hours, days, months, years possibly to determine that, where something that happened to you was in seconds. So you want to go to continue on the
next one is just stand your grounds until we get there.
There are 4 rules you have to meet to use deadly force in Connecticut to defend yourself properly. The first one is you fear that you're in imminent danger of death or grave/great bodily harm. So you fear you're going to die or be seriously injured in a way that you could die. So the example I like to use is like a machete. Right? Somebody coming at you with a machete. Could you die from that? Yeah. Could you also live from that?
You could die from being pushed on the stairs too. I mean, any of those.
You could, but
like your neck.
Yeah. Let's stay on the topic over here. So that's rule number 1. Rule number 2 is you have to be the innocent party. You can't be seen as the aggressor or an active participant in this conflict. And one of the examples that's given in this USCCA curriculum is in a bar. So you're in a bar and somebody bumps into your shoulder and you mutter the word asshole under your breath. And then this individual shoves you and you shove them back. They go down to the ground. They stand up. They pull out a knife and you shoot them in self-defense. Muttering that word asshole makes you an active participant in that conflict, and you fail rule number 2 now, and you're going to be charged with something. And we'll go over what you could be charged with here. Rule number 3 is no lesser force is available or sufficient to stop or end that threat. One of the examples they give in the curriculum is, let's say you turn down a dark alley and an individual jumps out from behind a dumpster. They pull back their shirt. They have a semi-automatic tucked into their waistband, and they start to pull out the gun. So you pull out your gun and you fire 2 rounds. One of them hits in the shoulder. One of them misses. The one that misses goes into a brick building. You're fine. And they drop the gun. The gun slides under a dumpster, right? And they start stumbling towards you. You continue to yell commands until they're within 25 feet. And once they're within 25 feet, you shoot them again. Is that okay? The answer is no.
No, they lost their gun. But that's away from Castle Doctrine too, just so you understand. This is more we're getting to self-defense. But
we're using number 3 as our example. If you had pepper spray in your pocket, for an example, that lesser force would have been sufficient to stop that continued threat. And then number 4 is you always have a duty to retreat, and that duty to retreat does not end. Castle Doctrine comes into play here when you're inside what's called your domicile, your dwelling, your home, or temporary domiciles like a hotel room, for an example.
Well, some states even do cars, but we don't.
Correct. So you have the right to defend your home. And you will see different interpretations of this on the stand your ground aspect. Do you want to read that?
Yeah, but I have a quick question before we
Yeah.
go any further. So we have a castle doctrine to defend our home, but at the end of the day, if they're just stealing your stuff and not actually looking
Let
for
them steal
you,
your stuff.
you don't have that right. It's
Correct.
with only if you
are an
imminent threat.
You are an innocent third party are going to die or be seriously injured in a way that you could die. It's only a person. You cannot defend property with deadly force, with lethal force. The only example of this in curriculum is arson. So if they're going to actively burn down your house, right, they're pouring gasoline around your house, they're about to light a Molotov cocktail, then that. Or maybe there could be an example, and again, not a lawyer, preferencing this throughout this entire example. There are, two guys with guns in their hands and they're at your front door trying to kick in their front door, and you clearly see they have guns in their hands. Right.
But that's still a maybe, maybe
it's
not.
Still a maybe, maybe not, but I'm going to go and
chance.
take the jury trial on that one.
Yeah.
Right. Most people have Ring doorbells or something like that. I'm going to take the jury trial on that one probably.
And in the process, call the cops.
Correct.
So that they hear that what's going down and know that they're listening.
So we don't have stand your ground in Connecticut. Let's be pretty clear on that from the get-go here.
Oh, it says it straight out.
So stand your ground does not exist in Connecticut. Castle doctrine, for layman's terms, is stand your ground in your home and only in your home. The four walls and roof of your house. I say this in class all the time. Not your property line, not your porch. I don't care what example you're going to ask about your porch. No, not a detached car garage. There can be an argument for something like a raised ranch where you have your garage. It's part of your home. But what are they doing in the garage? Are they trying to steal your car? Because then you can't use deadly force to defend property.
Right.
So be aware of that. But go ahead with the stand your ground.
So the stand your ground definition is stand your ground laws allow someone to use force in self-defense when there is a reasonable belief of a threat without an obligation to retreat first. 20 states, excluding Connecticut, have stand your ground laws. Generally, these laws require the person to, 1, have a legal right to be in the location, and 2, not be engaged in an unlawful activity. So for Connecticut specifically, it's written pretty clear. It says Connecticut does not have stand your ground law, but instead requires an individual to retreat when able to do so. Under state law, the use of deadly force that might otherwise have been justifiable is not warranted if someone knows that he can avoid the necessity of using such force with complete safety by retreating. So that goes to your properties, when you're outside. It goes to if you're in a store, if something happens in a store. A lot of these different scenarios, somebody comes up to you and decides to just be mouthy. You don't have the right to engage them, like he said, because then you become an active party. And then when you're in danger, get into trouble because you've already instigated and kept it going versus just walking away.
So when it comes to castle doctrine, here's a good little cheat sheet for you. Inside your home, you do not have a duty to retreat. You can use deadly force if you meet that criteria, and you do have castle doctrine. If you own a business, so I own Lock and Load, I have castle doctrine here as the business owner. My employees do not. So that's an example.
I thought they did if they are there lawfully working. Like if you look at what it just says here. So let me just ask you.
Because it's still under 53A20, which is the normal castle doctrine.
It says, who possesses or controls a premises or is licensed or privileged to be on such property.
Okay, there could be an argument.
I mean, it wouldn't be cut and dry.
Yeah, there wouldn't be cut and dry. But that's going to be an attorney.
Giving the employees the ability, if you're not around, to protect, especially a gun store.
What? Yeah, so if somebody comes in and one of them uses their firearm in self-defense, they're using it because they are in imminent danger of death or grave bodily harm, not the general store aspect.
Correct. Okay.
And then outside in public, you have a duty to retreat. You do not have castle doctrine because you're in public.
Yep.
or in a public building. That is not, you don't have castle doctrine in that aspect. You do not have that in a general, grocery store or something like that. That does not exist. You have a duty to retreat, and that duty to retreat does not end. There's one caveat to the duty to retreat aspect that I think is probably something we should explain, or I should explain. You're not expected to leave a companion behind. So if you're with grandma who's in a walker, and
They can't retreat.
they can't run, you are not expected to leave them behind.
Same with children.
Depending on how big the children are,
Small
pick
children.
them up.
Yeah, unless you have like 4, which some people do. It's like mama
Put them in the grocery cart.
Okay.
See, I'm giving you guys an idea.
Okay.
See, thinking outside the box.
Well, and you want to think. You don't want to put yourself in a situation to have to defend yourself, like in legal terms.
Yeah.
Forget about that moment. But if you feel that that is the way you need to go, and you need to use deadly force to protect you or your loved ones, that's what it says, then, understand you're going to be dragged through the courts. But if you feel it was worth it, well, then to me, it would be worth it. If that's where my moment went, and I went, I don't have a way to get away.
And then the last one is, if you can't physically escape, let's use this room as the example. I don't know how many of you have been in our classroom, but obviously there's a front door and there is a back door. Let's pretend there's no back door. Let's pretend there's just a front door. And a guy comes in here with a knife, right in the middle of the podcast, right? And, is a little off. And, Michelle and I he's threatening us. Michelle and I are giving him commands to, back up. And once he's in within a certain zone and we feel that we're threatened and we have no other choice, there's nowhere for us to retreat, right? There's no room to go by.
He's blocking the door.
There's only so many options you have at that point. He's blocking the door. And that's if the back door didn't exist, right? There's nowhere to retreat here. So there's always different stipulations, different
scenarios.
Thank you.
Scenarios are, thousands and thousands and thousands. And you can't, you, me, John, Joe, none of us can think of every single scenario that somebody may be in. So you need to have this information so you can make the best decision for you if you're ever in a terrible situation like this.
Correct. So practical takeaways, kind of recapping. Inside your home or legally occupied premise, you can legally stand your ground and use reasonable, if necessary, deadly force without retreating. Castle Doctrine. Outside of your home, you always have that duty to retreat, and that duty to retreat does not end. That's Castle Doctrine for you to a T, guys.
So I have a question, though, to kind of expand on this, because we talk about self-defense all the time. People carry for self-defense purposes and this, that, and the other. And then we talk about Castle Doctrine, stand your ground, which we don't have. So a lot of it's kind of convoluted, because self-defense, I guess it falls under the whole if you can't retreat. But that's the only time you can really defend yourself. The reason I'm saying this is I want people to understand, you have to be, it has to be a last resort. By the time you pull your firearm or you hit somebody with a lead pipe or whatever the case, whatever you can get your hands on, if it's going to do, as he said, deadly force to the person that is attacking you, you need to make sure you have done everything in your power, and that is your last resort.
So I'm going to go over, because you kind of brought it up there. It's called the use of force continuum. This is straight from USCCA curriculum. They give you rules you must follow. So I'm going to give you the example here and what happens if you don't follow it. So when you're exposing your firearm and or pointing your firearm at the person, you must reasonably fear that you have a threat against yourself or another person, and any force used must be reasonable for the circumstances. If you do not follow the rules, you could be charged with a misdemeanor or gross misdemeanor assault, terroristic threats, or brandishing a firearm, possibly felony assault or attempted murder. Shooting at somebody, shooting and killing somebody, you have to follow the 4 rules that we covered before. Reasonable, imminent fear of death or grave/great bodily harm to yourself or another person, you must be the innocent party. No lesser force is available or sufficient to stop the threat, and you have no reasonable means of retreat or escape. If you do not follow those rules, you can be charged with manslaughter in the first or second degree, murder in the first, second, or third degree. And I'm sure there's other charges. Those are kind of the generic catch-all charges.
Well, and you don't talk if you're in a scenario like this, whether it's in your home with Castle Doctrine or just doing self-defense out wherever you are, if you're trapped and have to use your firearm or whatever the case may be, call a lawyer.
So
Don't talk to anybody until you talk to a lawyer.
Correct. We've done throughout the years here, we've done legal seminars with two attorneys. We've done with Greg Miller when we were U.S. Law Shield partners, and now we've done it with Dave Catello, where we're USCCA partners. Dave Catello is a criminal defense attorney. He's one of the attorneys I'd really recommend for this because that's his job. That's his specialty. And so he comes in quarterly and we'll do a legal seminar. We'll send out a mass email for that and Facebook posts and all that stuff. It does cost $10 to attend. And he goes over all this stuff, and then it's a kind of a Q&A, and you're able to ask him questions. And then,
well, and it's super important because when you're stressed and you're in a situation like that, the only thing you want to do is talk. You want to just babble.
The number one thing he said is do not talk. Shut your mouth.
Give him your name and number.
Job
that's it.
Easier.
Yes.
The less information you give the police, the easier his job is. And it's not because you maybe did something wrong.
Or you're being an idiot to them, or you're just trying to be difficult. It's not at all to protect yourself.
Correct. The cops are there to gather all evidence and facts, but you have no idea what is going on through your own mind.
You're in shock.
You're in shock. There's another class that I've taught. It's called 6 Things You Didn't Know When the Police Arrived, which is a whole other part of the curriculum. But in the beginning of that curriculum, it talks about how your brain and body works under stress, which is very weird if you've never been taught this. We were one of the pilot classes for the USCCA before they rolled it out. And it was a really cool class. I got the curriculum 30 minutes before I had to teach it. So that was super fun. So we winged that first class with like 40 people. I had to learn the word amygdala on the fly. I know it really well now. Didn't know it really well then.
So tell the people what's amygdala.
It's in your brain. I couldn't say the word. That was the problem.
Yes.
Spell the word amygdala.
Amygdala.
Anyways,
okay.
if you want us to do any of these curriculums that I'm actually certified to teach, I can start doing little episodes on these. It'll at least fill some podcasts.
Or if you come, but if you come to these class,
classes,
because not for nothing, guys, when you sit in a class with other people, somebody may ask a question that you wouldn't have even thought of, but it makes a huge difference. It's like, oh, yeah, that makes sense. So the classrooms are actually really good for the interactive aspect because now it's not just your brain working and how you're thinking and what you're thinking of. Now it's a whole classrooms, of brains that are thinking in different areas.
Yeah. And like you might think of a question and somebody else asks it and that might lead down another rabbit hole or question. Go to those classes. They're all over the state. I mean, obviously, come here, guys. But they are all over the state at different stores. Some are great. Some are okay.
Well, and they're free or they're minimal as far as the cost.
They did go back to free because they learned that nobody was signing up for the $10 ones.
But it makes sense, guys. I mean, this is free education, free knowledge. Why wouldn't you take advantage of the education if you don't, especially if you're not paying for it? I mean, even at $10 is really not a bad deal either, but it is what it is.
Oh, anything else to add?
I don't think so. I think it's tough when it comes to self-defense. A lot of people think, well, I'm okay. I have this for self-defense. The problem is even when you're completely innocent.
In this state, you're still screwed.
Yeah. The stress and the money it's going to take you to be innocent is overwhelming for so many people. And lawyers, yes, they're great. And you have some that, will look at it and go, oh, this is going to be nothing. We got this, no problem. Then you've got others that are going to have to fight a little harder for it. So the only thing I could say as far as this goes is, be aware of what the laws are. And even though you're in shock, even though you're going through these huge, emotional steps as somebody's coming at you or whatever the case may be, keep in mind, is it worth it? Do I need to? Is this the moment? Because I know a lot of people who have gotten into trouble because they've pulled guns or hurt someone too soon. And I know that sounds kind of silly, and because maybe the way I'm wording it, but it was too soon. So
Yeah.
the state
They
could
jumped
actually
the gun.
But they had a very hard time fighting that and proving that they felt that scared.
Yeah.
Because they were like, well, you still had time to do X, Y, Z. Because, the ones that are looking at this, the courts that are looking at this, they weren't there in that moment.
And in Connecticut, they're not gun-friendly courts, guys.
No, none of them are.
Unless you're the actual continuous criminal, then they're gun-friendly. Something I'm going to add into that is get some sort of insurance program.
Yeah.
Whether that is USCCA, US Law Shield, CCW Safe, probably not Attorneys on Retainer. Go do your research on that one.
Well, they're good in Connecticut now.
Oh, are they again?
Yeah, they're good in Connecticut again, and they've actually changed and restructured quite a bit. They've actually are coming back.
Do your research.
Yes.
There are plenty of programs out there. I'm partial to USCCA. I also maintain a US Law Shield membership. So I have both for various reasons.
They do different things.
They do different things, and there's different attorneys.
Correct.
Huge pro with USCCA is the cost of bond. I think they go up to $2 or $2.5 million in bond now, which is insane. Mm-hmm. Huge pro with US Law Shield is Greg Miller. Oh, yeah, that's one of the huge pros.
And he answers the phone 24 hours a day.
So a customer yesterday actually had an unregistered other, didn't know about it, asked the question, and I'm like, I'm so sorry, man.
Here you go.
And I'm like, so I asked him how it was sold to him. He sent me the DPS-3, and I'm like, go call Greg. And so we're working through that. But Greg picked up, gave him the answer, and moved on, like no charge or anything. And he wasn't even a member.
Oh, wow.
It was just, so that was very nice. But get something, guys. I don't care what you have. Something is better than nothing at the end of the day. For the minimal fees, like you guys pay more for Netflix or Hulu or Peacock or whatever the hell else.
A gun.
Or ammo. Two boxes of ammo.
Which you got to do because you have to practice or you want to practice, whatever the case may be. So I'm not knocking that. But this is important too for long term. You don't want hundreds of thousands of dollars of legal fees simply because you were protecting yourself and the state doesn't recognize that.
And the state's not getting any better, guys. Crime is, according to Ned, down. According to everyone else, not.
No.
It is up.
Every day on my phone, when I don't know what I get, but I get news briefs all the time.
News break.
All day long. It's Waterbury shooting. This one got this,
Waterbury.
Or it's road rage.
Yeah, road rage.
It's there's stuff everywhere. There's a break in here. There's a break in there. Yep. There's, you name it. There's, homicide here. I don't know what news or what facts Ned's looking at. Not a clue, because it's crazy out there right now. And it's not getting better. And I deal with a lot of law enforcement, and whether you're biased or not against the law enforcement, they know what they see every day.
Yeah.
I had a gentleman an officer who is on the Waterbury Drug and Gang Violence Task Force. He's very busy. I'll just leave it there. Just very, very busy.
I bet. So
I don't have anything else on this. Do you?
No. So comment below what you guys want to hear next from us. We have, a few more podcasts lined up, another guest lined up, trying to get more guests. And comment below who you want to see on here, or if you have other topics you want us to discuss. Other than that, my name's Josh.
And I'm Michelle.
And we'll see you guys next time.
Bye-bye.
Lock and Load Podcast is sponsored by Lock and Load Firearms, Connecticut's #1 rated gun store and pistol permit class on Google. Come check us out, 1573 Meriden Waterbury Turnpike in Southington. Lock and Load Firearms.
Lock and Load Podcast is also sponsored by Patriot Wear Holsters, custom-made Kydex holsters locally made in Waterbury, Connecticut. www.patriotwearholster.com, and use code LNL podcast for 10% off your purchase. Orders available for shipping or pickup at various locations.